Welcome to Off the Record, a legal podcast.
Welcome back to Off the Record, a legal podcast with Rhett Burney, an experienced attorney helping families across the upstate of South Carolina with estate planning, probate, and family law. Rhett has spent more than 30 years helping clients plan for the future, and as more families include stepchildren, half-siblings, and second marriages, estate planning has become more personal and more complex. My name is Kevin Rosenquist, and today we're talking about how to make sure your will protects everyone you care about and prevents misunderstandings among the people you love most. Rhett, welcome back.
Hey, Kevin. I can't wait for this one. Let's talk about people and what they do to make their lives and loved ones a little mad at them.
Well, blended families, they're becoming more and more common. We see them all the time. You know, what really makes estate planning more complicated when multiple families are involved?
Yeah, when you bring people together that may not see eye to eye, because when you have the blended families, inevitably you're going to have a child that's not of the new relationship, but was of a previous relationship. And what we're trying to do is get people away from wanting to do just a simple will that says everything to my spouse and then to somebody else. Because what happens is you lose control. Once you die, you lose control of your assets because now they've gone to your new spouse, who can then do whatever they want to with them. That means they can sell them, they can give them to their children, may not even give them to your children. So we start looking at it. We start steering people to trusts, because that's one of the first things when people come in and they say, hey, do I need a will or a trust? First thing I ask them is, do you have a blended family? Because if you do, that's when we need to start talking about drafting a trust, so that when you die, if you want your children to get part of your estate rather than your spouse's children, that's one of the methods that we use in a trust to make sure that your assets go where you want them to go, rather than trusting that spouse who may try, once you die, may do something completely different than what you wanted to, giving your estate assets to their children or to their new 25-year-old spouse that they marry once you pass away.
25. How, when it comes to, if someone doesn't have that will, doesn't have that trust, how does South Carolina law treat stepchildren or children from a previous marriage when someone passes away?
Yeah, they don't treat them like children. They treat them as something else. They don't inherit from you. So that's if you and hey, look, there are lots of families, blended families, that get along great, and they never adopted the other children, and so you want to make sure they're protected as well. That you name them or specify that your stepchildren are to be treated like your children.
When you meet with couples, who come to you, they have children from prior relationships. What kind of conversations do you encourage them to have early in this planning process?
Yeah, we start talking about the dynamics of the relationship. What is their relationship like with their children? Do they like their children? They may not like their children. That's not unusual. Are there any addiction issues or criminal issues that we need to worry about? And at the end of the day, children mature differently. There's some that are not responsible with their money. Do we need to make one of the children, the responsible one, in charge of the estate or the assets after both parents have deceased? And now we're having to make sure that one child who spends their money very carelessly doesn't blow through the money. So I like talking about the dynamics of the relationships and just to see where everybody is, because that dividing the assets is easy. It's just making sure that it's done in a way that's responsible, and that the people who are making the wills or the trust, are keeping the control over it like they need to. Because Kevin, I don't know if you have siblings or not, but you may have one that you can trust with everything, and then another one you can't, and that's not uncommon. So we talk about those types of things. And then we start going through the different scenarios that are out there in order to make sure that Sometimes we just have to protect people from themselves. So that's usually the main thing we focus on when we start talking about blended families is what does the family really look like? How close are they? Do they live in different states? Do they rarely see them? Are they, living in the house with them, helping them? Let's make sure we do this fairly because, like you and I've talked about in previous episodes, the last thing we want to do is to create a problem when we're doing estate planning. We want to make sure that we're preventing problems or stopping problems before they occur.
I tease you sometimes saying that you're kind of sometimes more of a therapist or at least partially a therapist in these situations. Do you feel like you have to kind of help clients find a good balance when they're dividing assets among biological and stepchildren? Because everyone wants to be fair, but fair doesn't always mean equal.
Yeah, and what people don't realize is these aren't just forms that they are, but we put thought into them. And so we may meet more than once, more than twice, three times or more, as we have that first consultation. I tell them, hey, these are the different things you need to think about given the family dynamics that they've explained to me, because they haven't thought about certain things. And so there is a lot of therapy, I guess, a lot of counseling. And I tell them, hey, let me be the bad guy in this, to blame everything on the lawyer, but also want them to think about the different things that we see happen to help prevent them from being the next one that we're having to fight for in court in order to make sure the estate is handled properly.
You mentioned before that when someone comes into your office and says, "Do I need a will or a trust?" If they are a blended family, you recommend a trust. You kind of touched on a little bit, but can you unpack that a little bit more as far as like what a trust does that a will wouldn't, that would make you suggest that in that situation?
Yeah, and I'll try to simplify it. So I'll use some non-legal terms. So when you have a will, it just says, take my property and disperse it how I've said in this will. So you lose control over your property. Well, you're dead, right? But then all your property goes according to your will. With a trust, the trust owns the property. And so the trust doesn't die until, through the terms, it eventually expires. So when I'm making a trust, let's say for myself, I'm handing the assets to this trust, which then holds it for the benefit of me while I'm alive. And then when I pass away, it's holding those assets for the benefit of someone else, perhaps my spouse. And then after my spouse dies, then it holds it for the benefit of maybe her two children and my two children, so that I'm not just handing, when I pass away, all of my assets to my wife, who can then do whatever she wants to with them, disperse them, sell them, give them away, or what have you. I'm still keeping control over those assets because I've created this entity, this trust that's now holding my assets for a particular purpose to make sure that it's used according to my desires. Does that make
Okay.
sense?
Yeah, it definitely does. Yeah. Yeah, that makes a lot of sense. So is a will still helpful or in that situation or not as much?
Well, if you have a blended family, I would say don't do a will. But yeah, wills are great. There's nothing wrong with wills. I have these conversations all day long with clients who come in and they hear that they should have a trust because it avoids probate. And I'll start asking them about their assets and about their family dynamics. And I might tell them, hey, I'm happy to do a trust. I make more money when I do a trust because it's a lot more complicated. But their situation may not necessitate them doing a trust. It may just be a simple estate that we can set up different things so that their desires are still carried forward without having to go through the complexities of a trust. And I don't want to oversell somebody in that regard. And I'll tell them that, but they still may want to trust, and that's great. But I don't necessarily think that everybody needs a trust, nor does everybody need a will. But remember this, so people don't get confused. When we do trust documents for clients, we do a will as well, because inevitably, if an asset is not owned by the trust, either being in the name of the trust, that it will not be part of the trust.
Oh yeah.
So we'll do a pour over will that says if you've left out something from the trust, then it goes through the will pours over to the trust and now is an asset of the trust.
That makes sense because we've talked in the past about people forgetting to fill the trust or forgetting to add things when they get it, when they acquire new assets, putting it in the trust. So yeah, that makes sense why you would want to do that. When it comes to beneficiary designations on things like life assurance or retirement accounts, do they override what's in a will? Does it all sort of talk to each other, work together?
Yeah, so I'll give you an example. So it'll probably help in the explanation. So if I put in my will that Kevin gets all of my stuff, all of my stuff, and the only thing I own is a life insurance policy, but then I've left the life insurance policy to Mary, then no matter what I put in the will, the life insurance is going to go give it all to Mary.
Okay.
Because that life insurance policy is a contract between me and the insurance company. And so I've named Mary as the beneficiary, so she will get that. Even though I've said in my will that you're getting everything. It's also like this. So if you have a bank account and you name me as your beneficiary, even though you may have left that to your wife in your will, because you've named me as your beneficiary on that bank account, I will get that account, not your wife. So a will not necessarily override, whoever you've named as a beneficiary on a bank account or a life insurance policy.
That's probably a good tip for people, because they probably, especially if you have life insurance and retirement accounts and you have an estate plan, it's probably pretty easy to forget to update. If you're smart enough to update that estate plan,
Yeah,
it probably is pretty easy to forget to update the life insurance and retirement accounts.
everybody does it. Everybody does it. We just put it aside and don't think about it, right?
Sure. Yeah.
You don't think about it. I mean,
No.
you probably couldn't tell me who's on yours right now, unless you did it recently, and that's how most people are. And so it's always good to go back and check to see how you have it listed. I went back and checked mine, and they had my family's name spelled wrong. So I had to go back I had to go back and fix that. And I thought I filled it out correctly, but they didn't enter it correctly. So it's always good to kind of have that. I wouldn't say do it yearly. That's probably too much, but you do it periodically just to make sure that it's how you want it to be.
Yeah, I think that's good advice. What would you say to any blended families listening right now who are like, yeah, we probably need to start thinking about this? What's a good place to start? Because it seems like it could be sort of overwhelming. What's a good place to start?
Yeah, a lot of it depends upon the ages of everybody involved, but I think a good place to start is to sit down with a lawyer and talk about the dynamics.
Mm-hmm.
Because depending upon where you are in life may dictate what you need to do with your estate. There are different vehicles to think about in order to properly do what needs to be done. A 20-year-old couple with 2 kids on each side might be a little bit different than an 80-year-old couple with 2 60-year-old kids on each side. So I think it's always great to go ahead and sit down and talk with a lawyer. Most don't charge you just for that consult. Even if they do, it's well worth it because you have worked for these assets, and paying a few $100s for a consultation fee to get the right answers is a lot wiser than going online and trying to chat GPT it or Google it and think you might get the right answers, because those types of models, or they're just going to tell you something. But a lawyer is going to be able to talk you through different scenarios.
Right. That are specific to you too.
Yeah, because everybody's a little bit different. There's very rarely the same type of situation. Similarities, yes, but never anything that's 100% the same.
Yeah, I definitely agree with that. All right. Well, thanks for joining us on Off the Record, a legal podcast with Rhett Burney of Rhett Burney Law in Simpsonville, South Carolina. To learn more about wills, trusts, and estate planning for blended families or just in general, visit rhettburney.com. Don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Rhett, always enjoy sitting down with you. Thanks so much.
Thank you, Kevin. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.